service and well-being of the people of India. When a minister takes oath, he says, or a prime minister, I will do right to all manner of people in accordance with the constitution and the law, without fear or favor, affection or ill will. Whereas when a judge or a Chief Justice of India takes oath, he says, I will true bear faith and allegiance to the Constitution of India by law established, and I will uphold the sovereignty and integrity of India. I will duly and faithfully and to the best of my ability, knowledge and judgment perform the duties of my office without fear of favor, affection or ill will, and I will uphold the Constitution and the laws. So whereas the President has to defend the laws, the executive has to implement the laws, the Chief Justice of India or judges have to uphold the laws and the Constitution. The distinction in the Constitution of the functions of the various organs of the state are quite clear and stark. The distinction is that the executive is enjoined to work in accordance with the Constitution, whereas the judiciary is to uphold the Constitution. So if there is a failure by the executive in delivering in terms of the Constitution, then the court has a very important role to play in upholding the law as laid down by the Constitution and the laws framed by this in this country. So this, I remind, I'm sure Justice Chandrachud is one of the brightest judges we have, and I'm sure that he doesn't need any reminding. But with a long 2-year tenure for him, I'm sure he will do the very best to ensure to uphold the Constitution of India. Justice Chandrachud was born in 59, as we all know, son of the 16th Chief Justice of India, Justice Y.B. Chandrachud. His mother, Mrs. Srimati Prabha Chandrachud, was a singer in All India Radio, and Justice Chandrachud was known to have been an avid fan of his mother's music teacher, the renowned Kishori Amonkar, who was a regular visitor at their house. An autograph taken by a young Justice Chandrachud sought from Mrs. Amonkar read, "Music musically leads to silence," a message that is known to have left a long-lasting influence on Justice Chandrachud. At the age of 12, he shifted to Delhi when his father was appointed here, and he studied here in St. Stephen's College as well as in Campus Law Center. He was a topper in St. Stephen's in economics, and we all know economics topper means one of the brightest in the country. And in that era, for him to decide to take law for a topper of economics was a great thing for our profession, because in those days, I would say, I'm also that same era, the not so good students were primarily coming into the legal field. But for him to be a topper of economics and when having the option of going into any branch he wanted to do in the country, he chose to come into this profession, is a great asset for all of us, and he is here with us as Chief Justice of India for the next 2 years. He not only finished his law campus law center as a topper almost every year. I believe he and Parag used to be either 1 and 2 in every year, every batch. But after doing that, he went and did a scholarship, INLAC scholarship, which is again a very prestigious scholarship. And he went to Harvard, he did his master's, and then he did his PhD and got a doctorate from there. and that is why he is referred to as Dr. D.Y. Chandrachud. He has been involved in social causes, and that is reflected in his profession also as a lawyer. He represented a worker who was denied employment only because he was suffering from AIDS, and he got him relief, saying that this can never be a justifiable ground for denying somebody an employment. He was also involved in academics as a lawyer, and he was a visiting professor of comparative constitutional law at the University of Bombay between 1988 and 1997. 1998 was a very big year for Justice Chandrachud. He was designated as a senior in June, despite being only 38 years old then. Normally, designation doesn't come below 40. And he was also made the additional Solicitor General the same year. He continued as that for 2 years till he was elevated when he became a judge of the Bombay High Court on the 29th of March 2000. Justice Chandrachud was sort of that feminist approach perspective that he got in his life was his sitting with Justice Ranjana Desai, and he, because of that association with her, he could understand the importance of ensuring gender justice, and that reflected in his judgment in the case of Nitisha, where he ruled that a lady officer in the army had a right to permanent commission. And he developed the concept of indirect discrimination. And with that judgment now today, women are being given permanent commission in the army, and it's a great step for our country. Justice Chandrachud believes in hard work and discipline. He once concluded a hearing in the Bombay High Court by sitting early hours for 7 days to finish that matter. Even in the Supreme Court, while sitting with Justice Hema Kohli, he remarked when somebody wanted an unnecessary adjournment that we don't want to become a court of Tariq pe Tariq. We must bring a certain amount of sanctity in the way the Supreme Court is functioning, and you can't take this court non-seriously. Justice Chandrachud was appointed as the Chief Justice of the Bombay High Court in 31st of October 13, and he was elevated to the Supreme Court on 13th of May 2016. Invariably, these felicitation functions turn out to be a function for making a demands on behalf of the bar. And it becomes important because the idea of felicitation is all that we normally speak about. The judge is normally said at his retirement. So at the time of felicitation, we feel that the bar issues can also be raised and seek a response of the Honorable Judge, Honorable Chief Justice of India, on some of those issues, if he feels that he has something to say on many of them, because these are very live and pressing issues of the bar, not only of the bar, for the judiciary as a whole, and it will have a very lasting impact on the justice delivery system. One of our very, very major issues which has been pending for a very long time has been the elevation of our members to the various high courts, and it is really not understood. In these days of criticism to the collegium system, I am sure Justice Chandrachud will put in a credible system in place to ensure that our members are regularly considered for elevation to various high courts and elevated only on their merit. We don't want any favor from anybody. We don't want anybody to be elevated if he doesn't deserve to be done so. But if we deserve to be elevated, our members deserve to be elevated, we must have a credible system in place for doing that. And for that purpose, some out-of-the-box thinking will have to be done, because the collegium in the high courts don't have a direct access to the nature of practice being done by our lawyers. But I'm sure there are clearly discernible ways of seeing the kind of reported judgments you have, the kind of income tax you file, etc., which could be a basis for picking up names on a regular basis and seeking their consent. Because invariably I've seen, and that's my experience in this 32 years of this court, that lawyers who are not asked to be elevated as a judge at the right point of time do not themselves show any interest because they are doing very good in practice, and if you don't give them the proper due regard at the right time, you lose that person from the system, which ultimately is a great loss to the institution. In fact, Justice Sanjay Kaul has also in a judgment last week mentioned about this delay in the collegium system and how good names are wanting to withdraw or not put up their candidature at all in the fear of names getting delayed for elevation. And that is something which is a very serious concern for the members of our bar. The other concern is, of course, with regard to elevation to the Supreme Court. The issues which always have been in this court has been that it should be merit as number one, most important, number two, regional representation, and number three, seniority. And there are several high courts today which are unrepresented, including my high court, which is Patna or Jharkhand. And I'm sure there are several other high courts. I believe Orissa also doesn't have a representation here. So the Honorable Chief Justice of India, who has a tremendous opportunity to not only fill up the 6 vacancies which are already there, but to fill up another probably 15 or 16 vacancies in his tenure, to ensure that these issues are always taken into consideration, and also that elevation is done in a time-bound manner from the date of the recommendation. Like Justice Dipankar Gupta's elevation has been recommended more than 6 years back, and it should not happen that now that the collegium has changed, it should be sent back. That name should go as it is, and new names should be added as a separate list. The other more, I would say, housekeeping issues are that we require SCBA, Supreme Court Bar Association, was last given a space in 1991. Our strength has grown maybe 4 or 5 times since then. So we need another library, we need another ladies' bathroom, we need a proper lunch room, we need a place for the Supreme Court Bar Association. Rahul has already mentioned about these cubicles to be built in the complex because of lack of these cubicles now, our lawyers have been waiting for more than 20 years for a chamber, and these cubicles will go a long way in meeting this problem. We require a proper medical facility, and Rahul has already mentioned, and we had a meeting with the Honorable Chief Justice of India, and he has already instructed, and we very recently had 3 instances where our lawyers were critical inside the court, and our facility, which is meant for lawyers, was not sufficient, and we had to be taken to the judges' facility, which of course was immediately given to us. But we want that there should be some facility because the number of lawyers are very large, and this should not ever happen that we lose a life because of lack of facility in the Honorable Supreme Court. We require a bigger space for creche because the number of women who are practicing in the Supreme Court is growing. Even the registry officials use the creche. So the number of the creche which is at present in existence is a very small creche. That facility can be increased. Pradeep Rai has already mentioned about entry, etc. That definitely need to be streamlined. Listing, a lot of our problems had already been taken care of by Justice Lalit, and we are quite hopeful that Justice Chandrachud, who has also had a very long meeting with us, will further streamline the issues of listing so that every matter which gets filed in this court should get listed within 2 to 3 days of its numbering. And that is our wish list, because in the Delhi High Court, if a matter can be listed the very next day, I don't see why the Supreme Court should not have these matters listed. And this will lessen a lot of your burden in mentioning, because most of the time which is wasted in mentioning is for getting the matters listed only. The senior designation already is being pending, so it has to be done twice a year as per the judgment of the Supreme Court. That also, sir, should be given due priority, because ultimately it's a expectation which every lawyer practices here who wants to become a senior to be elevated. Bar Council of India have been allotted chambers under the discretion by the erstwhile Chief Justice of India. The rules do not permit any such discretion. The rules permit only allocation by a system which is provided in the rule. The erstwhile rule had some discretion, so that immediately should be cancelled, and these chambers, which will be made available to people who are waiting for 20 years, will be available to them. So there is one issue which we have been writing for a long time, because when we faced this pandemic, we had a huge problem of maintaining the lawyers, because there was no work, and the majority of them had difficulty in maintaining their households also. So there has been a demand for having a lawyer's welfare stamp exclusively for Supreme Court, because Supreme Court is a very unique practice where lawyers come from various high courts, various states, and with the result that they lose their sort of birthmark or their on the initial listing from the original Bar Council, and they are a separate class which practice here, and they all come here, they have their own, they take houses on rents, and they start practicing here, and if some kind of a calamity happens to them, there is no way, there is no social security for them. So a lawyer welfare stamp for the lawyers will go a long way to ensure that we as, in the association are able to tide over these problems of the bar. And with all my long demands, sir, I will now once again wish you a very fruitful and I'm sure a decisive tenure. I'm sure in this tenure you will be able to take not only the Supreme Court, but the entire judicial system, the entire judiciary of this country, because you are literally the karta of the entire judicial system of this country, that you will take the entire judicial family to greater heights and ensure that the people of this country get just affordable justice, affordable and timely justice. Thank you, sir.
Thank you, Vikas, sir. Justice Chandrachud was always academically very brilliant, was a topper in economics, master's and doctorate from Harvard, senior advocate at 39, High Court judge at 41. His judgments we all have read. And with regard to the demands which Vikas sir has said, with the temperament of Justice Chandrachud, we are very hopeful that all of them would be met. He likes to take everyone along. With this, may I now request Hon'ble Dr. Justice D.Y. Chandrachud to kindly give his address. My distinguished sister and brother judges and colleagues of the Supreme Court, Shri Vikas Singh, President of the Supreme Court Bar Association, our distinguished Attorney General, Mr. R. Venkatramani, the learned Solicitor General, Mr. Tushar Mehta, Mr. Pradeep Kumar Rai, Mr. Rahul Kaushik, distinguished senior members of the Bar, and all the other members of the bar who are present here. I'm really deeply grateful to you for organizing this felicitation event on my being appointed as Chief Justice of India. This has a very special significance for me because I commenced my practice as a young member of the bar in the Supreme Court. My father had made an announcement that I will not join the bar and be in active practice so long as he was the Chief Justice of India, because he believed that wherever I joined, that court in that sense would be
below the Supreme Court in hierarchy, which is what led me to 3 years of graduate education in the US, after which I returned. But on my return with an LLM and a PhD, an SJD as they call it at Harvard, I realized how uninitiated I was in the law. When I went to Mumbai, my first brief was given to me by a good friend to mention a matter before Justice Sujata Manohar. Then I asked him, I said, how much should I mark on the docket? Because you have these green dockets where you mark your fees in gold mohars in Mumbai. Each gold mohar is 15 rupees as opposed to Calcutta where I believe it is 16 rupees. I thought I would be given a reasonable fee commensurate with my educational qualifications. But he told me that, well, ordinarily a junior is paid 5 guineas for mentioning a matter. In your case, since you are being briefed for the first time by me, you can increase it to 6 guineas. So I had a fee of, a very, very royal fee of less than 100 rupees to mention a matter. That's where I began from. But I realized when I came to the Supreme Court to practice how uninitiated I was in the law. But I really learned my craft at the feet of the greats of our own bar and on the bench in those days, to whom I have an eternal debt of gratitude. One of my first briefs was given to me by Mr. Praveen Parekh from Parekh and Company to appear in a land acquisition matter before Justice M.P. Thakkar. I had not the faintest clue on how to argue a land acquisition matter, no clue about what sale instances are all about, and least of all was I aware of something called the Miriam's tables, which formed the basis. It was like an actuarial table in that case. So Justice Thakkar kept the matter the next day and said, don't sleep in the night, but get ready with a brief and come and argue the matter tomorrow. That became reported as Chimanlal Hargovindas versus State of Gujarat, on the basis of which I got several more matters. People didn't realize that the real credit for that judgment went to the judge and not to the lawyer, the young lawyer who was arguing the matter. So I really learned at the feet of the greats of the bar and the bench. I was briefed with Mr. Fali Nariman in a matter relating to the withdrawal of the prosecution of 3 chief ministers under section 321 of the CRPC. That was challenged and eventually referred to the Constitution bench. So when the judges were exchanging a conversation between themselves, I was keen to tell the senior on what is the next line of authority to cite. So he put his hand up and said, quiet, he said, quiet. And then he told me, he said, when the judges speak, when a matter is going on, always be silent and see what they are talking about. That will give you an insight on which way the matter is going and what they expect of you. Focus on the court and focus on what the judges are speaking about. Then in numerous conferences, I learned what we have now called, we have come to learn or label as the Nariman list of dates. Every time you had a conference, you would improve upon the list of dates. The dates would be distinguished from your submissions, which would come in the form of a note. There was Lal Narayan Sinha ji, the then Attorney General, who was understated brilliance personified. You could barely hear him behind the first row. But when you leant over and tried to follow what he was arguing, you were struck by the sheer brilliance in his simplicity, in the manner in which he made his presentation. You recall that he was the Attorney General who walked out of the court when Ram and Shyaman was being argued, that famous case on tenders. I was in the court when Mr. S.N. Kakkar was arguing a matter in court number 4. When a very strong judge, Justice D.A. Desai, was tearing a young junior apart. And Mr. Kakkar was pouring into his briefs, getting ready with his own case. And then suddenly he sprung out of nowhere and said, Lords, I protest at the manner in which the junior council is being dealt with by your lordships. And if I don't raise my voice, I would be unfair to the young juniors for whom I stand today. There was Mr. K. Parasaran. He would spend hours when he used to argue before the Constitution bench. The court was not, court number one, the Chief's Court was not as crowded in those days. So we would spend post-lunch sessions on days when Mr. Parasaran was arguing a Constitution bench matter and just listen to him expounding for 2 hours the bare text of the Constitution. Not a single authority in hand, but just the Constitution in his hand. Arguing from the legislative lists, explaining to the court how the legislative lists had to be balanced. I was once arranging books in the lunch hour in court number one when the irrepressible Mr. R.K. Garg walked in and gave me a slap on my back and said, "What are you doing? Haven't you had your lunch?" So I said, "I'm arranging the briefs for my senior." He says, "That's the problem with you Bombay lawyers. You only focus on efficiency. But where will the vision come from if you only focus on your cases? So look beyond the immediate brief that you are called upon to argue." Then, of course, you had Mr. Sori Sorabji, with whom I appeared in so many different cases. Precision, the vision of public law. He led me in D.C. Wadhwa versus the state of Bihar, a matter which went to the Constitution bench when the Bihar Ordinance Raj was challenged. And it all arose from a book which was written by an economist who was researching land tenures in the state of Bihar. And he found that ordinances were being repromulgated for 10 years, 12 years, 15 years without being converted into law. And that became the subject matter of a challenge which was really spearheaded by Mr. Sorabji, and that was the brilliant judgment of our court. There was Mr. Ashok Desai, who would talk to you about law, but he had a deep connect between law, life, and literature. I remember as a very young lawyer, I had gone to him on a Saturday to brief him. So after the conference was over, he asked me, so he said, "Young man, what is your poison?" And to which I answered in a very ignorant way. So I said, "I haven't yet decided to consume any, sir. I haven't come to the stage when I have to really look for poison." Only to be told later on that poison meant something very else, something very different in the analogy of Ashok Bhai. Dr. Chitle, about whom the Attorney General mentioned, Dr. Chitle never left the chamber even after work was over. He had a stipulated time to leave the chamber, which was typically at 10 o'clock in the night. So when the conferences were over, and many of those conferences were occupied by a very young Mr. R. Venkatramani, so very earnest and always on punctual time, he would just pick out a book from the library, whether it was the Restatement of Laws or American Jurisprudence or some book on the law, but never left until it was 10 o'clock and it was time to reach. And that's how the classical judgment in Central Inland Water Transport Corporation came into being. I was briefed once with Mr. Ashok Sen, and he said that I have no time for a conference, but if you don't mind, will you accompany me to the airport in my car and I'll tell you what to research over the weekend. So between the Supreme Court and Palam, I was occupied by just the sheer brilliance of Mr. Ashok Sen, who through his memory would throw cases at me and say, "Look, this is the citation, look at these cases, and be ready for me when I come back on Monday morning to argue the matter." So I can really go on endlessly. But I think what I am today and what I humbly profess to be is a product of what we have learned from the greats of the bench and the bar. Justice Sabyasachi Mukherjee, who was a judge of the Calcutta High Court, had the courage to say when the Supreme Court decided to intervene in a matter which he was hearing, that let wiser heads decide, he said. But though he said, let wiser heads decide, it's to the eternal credit of our institution that his career was not put in the back burner, but he was brought here to become the Chief Justice of India. You had the great Justice A.P. Sen, a little negative in criminal jurisprudence, and I was arguing a very interesting murder appeal before him as a young lawyer. So Justice A.P. Sen would always focus on the injuries more than the evidence. So he said to me, but there is nothing in your case. He said, don't you realize that the intestines came out? So I was so young and perhaps a little impetuous. So I said, my lords, it is because the intestines came out that I am here before your lordships to argue this appeal. Justice P.D. Desai, who became the Chief Justice of the Bombay High Court, a distinguished Chief Justice. Justice P.D. Desai would hold what we call the Desai Darbar every morning in the court, which was really the process by which he tried to mediate in matters involving small people, a young laborer, a widow who is asking for family pension. And his court would be full of litigants in the morning. And he would be spending a few minutes on every case trying to tell the employer or the government to settle that case. So we as young lawyers would just sit in the court and watch him in operation. And we possibly learnt a great deal about the great injustice which pervades our society and what is the plight of common citizens when they come face to face with power and authority of the state. Those were the judges who taught us our intuitive sense of justice and how they dealt with the problems of injustice which came their way. But we also learned a great deal about the importance of integrity at the bar. I was arguing a matter before a division bench of Justice Mohta and Justice Junjunwala. You see Devansh there in the third last row, his grandfather. It was a very important case, very high stakes for a sugar factory. We had argued the judges were dead against us. I knew that they were going to be against us, and the matter was finally listed in chambers a day before Diwali. So Justice Mohta turned to me and said, Mr. Counsel, would you like to take your chance before some other bench? It was just a day before Diwali. Now we're not really keen on proceeding with the hearing. Would you like to take your chance and go before some other bench? So I turned to them and said, my lords, I'm totally satisfied that I have said everything that they had to be in this case. And I'm also conscious of the fact that you are dead against me on this case. But I said, I'll rest the case there. Please decide as you now would like to decide. I'm conscious of which way the case is going to go. So they looked at me and said, well, it's very gracious of you to say that, but I think we'll leave this and you go before somebody else. Now we don't want to take this and keep it parted because benches break up after Diwali. So we went before another bench after the court themselves released the matter. Before the new bench, we succeeded with a full refund of tax in that case, which also leads you to believe that all litigation has a certain degree of its own kundali, as many seniors have always told me in the court. I had a 1966 model ambassador in those days as a young lawyer, without any air conditioning, of course. And so many of the seniors whom I used to brief, many of them are here, would be driven by me and my ambassador to maybe the Commissioner of Central Excise or to the MRTP Commission or wherever. I would take longer routes if only to have a better conversation with the senior and pick up a little thing or two, some tips on the profession. From Mr. V.M. Tarkunde, who was a very distinguished member of our bar, former judge of the Bombay High Court who came here. I briefed him once in a matter involving the Delhi hawkers. It was sheer poetry to understand the way he thought in the conference, expressed himself in the conference, understood the plight of hawkers, and he developed a whole universe which we had not even thought of when we briefed him. And that led to the judgment in Sodan Singh versus the Municipal Corporation of Delhi. So I do believe that while we are as judges of the Supreme Court, we owe a great debt of gratitude to where we come from. Because can the river, can the rivulet, can the stream ever rise above the source? So I believe I'm just a stream coming from this great source of the Supreme Court bar of the Indian bar, which I have greatly learned from and continue to learn every day of my life. Every day that you are a judge of the Supreme Court, you are constantly reminded of how vast the field of knowledge is. And in that sense, how much more there is to learn. Because you realize that no two cases are the same, so it's very difficult for a judge to believe that you know everything about a case or everything about a subject. Even if you have done 10 cases on the subject, there comes the 11th case which surprises you that you probably had made a very wrong assumption about the case. So I believe that much of the work which we do, or all of the work which we do, is a collaborative effort between the bar and the bench. When I was about to become a judge of the Bombay High Court, and a little reluctant to do that, in fact, I had walked up to Chief Justice Y.K. Sabharwal to tell him that, well, it had taken almost 3 years for my appointment to come. My late former wife was suffering from cancer, and we didn't know which way we were going. And I told him that, would you give me the liberty to now take my own freedom and leave the course of action which you have chalked for me? And he said, well, wait for a few months. But what really has been a part of my journey is this feeling of constantly being guided by others who are at the bar, of constantly being guided and shaped by others on the bench. And I think it's the same feeling which continues with me even today on the Supreme Court. I do believe that the Chief Justice of India, and for that matter any Chief Justice, even of the High Court, is what is called in Latin as primus inter pares. Primus inter pares, very simply put, means first amongst equals. My deep belief, watching Chief Justice in the Bombay High Court, being a Chief Justice of the Allahabad High Court for almost 3 years, is that first and foremost a Chief Justice is a judge. You can never forget the fact that you are a judge. And I believe that Chief Justices are either respected or they're not respected based on whether or not you do a basic function as a judge. There's an enormous amount of administrative work which you have to do as a Chief Justice. And I've been constantly told over the last few days that, well, cut down on the judicial work which you do and your propensity to cross time only because you need to focus on administrative work. But I do believe that it's your judicial work which is the most fulfilling aspect of your life, and that's something which there can be no making compromises on. And that's the way I believe I intend to chart my course for the next 2 years. Having said that, I think it's important for me to realize that the office which I hold is an office which I hold in trust. It's an office which I hold in trust for society, for our citizens. And I do believe that each of my colleagues with whom I collaborate every day are as good or better than me. And their experiences of life are as good or better than mine. Therefore, I would be looking at my own colleagues to give me the weight of their experience. The judges of the Supreme Court who are drawn from the High Courts bring to them, to their work, years and years of experience as judges, as Chief Justices of the High Court, and their collective experience and wisdom is something which we in the Supreme Court have traditionally not tapped. And that's one of the grievances, that's one of the critiques of many of our colleagues. And I believe I have to change that and depend more on my colleagues, draw out their experiences, because that experience will contribute to strengthening the institution. Likewise, our colleagues who have come from the bar, they have that freshness. We have become a little stale, we have become a little rusty, because even when I award costs based on what my scale of fees was. And sometimes when I award costs, I know that lawyers smile and laugh at me that, this man is completely out of sync of what fees today are as compared to what fees were when he was a judge, when he was a lawyer. So I believe that our colleagues who come from the bar bring this freshness about the bar. They have that connect about the bar. Just as Justice Nageshwar Rao had, Justice Hindu Malhotra had, Justice Lalit had, and of course Justice Narasimha has. So this is this unique combination of the bar and bench which comes together in the Supreme Court. We have judges who have come from the district judiciary, like Justice Bela Trivedi, Justice Bhanumati before her, who have years and years and years of experience of handling the grassroots reality of our legal system. We are people who are drawn from the bar who are elevated at a lateral point much later in our careers. But we have looked at the district judiciary. We know what the conditions are because we have worked as administrative judges in the high courts. We have traveled to remote locations. We know what the realities of our districts are. As Chief Justice of the Allahabad High Court, I know that well, and we were discussing this yesterday when we were with the SCORA members. There are district court establishments in UP when the prisoners are brought for the day's appearance in court. They're led by a staircase into a dungeon where there's not even a light or a toilet, and they have to stay there the whole day. Those are the realities. As the administrative judge of Kolhapur, Justice Oak and I, we were administrative judges of Kolhapur, one of the most prosperous districts in Maharashtra. When the young women, we had a district judge who was a woman, and she told us that there is no toilet for women judges in this district court establishment. And these young girls who are now who are judicial officers at the age of 25 and 30 and 35, they leave their home at 8:30 in the morning to come to the court, and they return home and can use a washroom only at 6 o'clock in the evening. And the district judges told us that, well, they don't go to the public toilet because they have to go past the under trials who are sitting just outside the toilet, and they find it extremely embarrassing to use the public toilet. So these are some of the realities of the legal profession, of our district judiciary. And I do believe that we have to change. If we have to change, we have to change the face of the district judiciary first and foremost. I think we have fostered a culture of subordination. We call our district judiciary as subordinate judiciary. I make a conscious effort not to call our district judges as subordinate judges, because they are not subordinate. They belong to the district judiciary. I have visited district courts where it used to be conventional, not in Maharashtra, mind you. Maharashtra is very different. It used to be very conventional for district judges to stand when high court judges are having their lunch or dinner, sometimes even try and serve the high court judges. That speaks of our colonial mindset. And I would always say that, look, we will not have our food unless you sit on the same table with us and have your food. As administrative judges of the High Court, you would often have district judges who would come to brief you as Registrar Vigilance or Registrar Legal. They wouldn't dare to sit in front of you as a judge of the High Court. You would stand up and discuss the file with you. So we would go out of our way and say that, well, if you are not going to sit down, there will be no discussion on the issue. Please sit in front of us and then we'll open the file. So a great deal has to be done not only in terms of improving the infrastructure of our district judiciary, which is extremely important, for which we have to lay the foundation blocks today, but we have to also change our mindsets about how we, as superior court judges, look at our own district judiciary, how we perceive of them. You would find that a young IAS officer does not look at a superior with a sense of inferiority. They would talk on a footing of equality. But that is not so in the judiciary. We have to ensure that when we deal with judicial officers, there are states in the country when the Chief Justice travels and crosses boundaries of districts, judicial officer would stand in a row at the end of the boundary of one district and before the judge enters another district. All this has to change. We have to ensure that we move towards a more modern judiciary, an equal judiciary. And unless we in the superior courts, be it the High Court or the Supreme Court, we realize that the district judiciary is really the core, it's the cornerstone of the judicial system. Nothing is going to change. And we have to inculcate the sense of self-worth in our district judiciary. Interestingly, now, many more women are coming into the district judiciary. The last recruitment which took place in the state of Rajasthan, over 60% of the new recruits were women in the state of Rajasthan. I found that there is a generational shift which is going on in the judiciary. There's a demographic shift which is going on in the district judiciary. When I was Chief Justice of the Allahabad High Court, if you spoke to a very senior district judge, every second sentence they would look at you and say, "Hanji sir." The younger lot of judges would be talking to you on a footing of equality because that shows where India is going. The young are educated, they are bright, they have aspirations, they have a sense of self-worth, they are confident about themselves. And that's the same about our young lawyers as well. So I think when we deal with our lawyers, and that's something which I try and do in my own courtroom, I try and deal with lawyers on a footing of equality, encourage them. Sometimes we appear to be harsh by not granting an adjournment, but we do that in order to enable a young lawyer to argue a case. Sometimes we make sure that the seniors sit next to the young lawyers. So all in all, I really begin by telling you that I'm not here to do miracles. I know that the challenges are high, perhaps the expectations are also great. I'm deeply grateful to you for your sense of faith. But I'm not here to do miracles, but I believe that my motto every day is that if this were to be the last day of my life, have I left the world a better place? This is what I ask myself every day. There is a brilliant book by a Stanford professor, and he says, well, you can never change the way, the hand that you are dealt with by destiny, the hand in the hand of cards, a game of rummy or bridge. You cannot change the way the hand is dealt to you, but you can certainly change the way you play the hand. And that really is, it sums up what we have to do. So many demands, I wouldn't say demands, so many genuine requests from both initially Rahul and then the learned president of the SCBA. I've been in conversation with the SCBA. After that, I had a very long conversation with the members of SCORA. I moved into both those meetings with a sense of trepidation on what comes next, but I was pleasantly surprised because there was a feeling of very great respect, of camaraderie between the lawyers who met me, each one of them, feeling of great affection and camaraderie. But above all, I found that every one of your demands is so reasonable. There is no unreasonable demand coming at all. The only question is, how do you accommodate those demands? And I'm sure, with the collaboration of my senior colleagues, you've been referring to the way in which the issue of the chambers was sorted out, the issue of security was sorted out. Justice Kaul dealt with the issue of security. Justice Suryakant and Justice Gavai dealt with the issue of chambers. In fact, whenever I had a 32 petition, I would say, why are you contesting a 32 petition? Just go before Justice Suryakant and Justice Gavai. And all those petitions were sorted out to the satisfaction of all the members of the bar. Of course, you can't please everybody all the time, but you can always try and make things easier and better for everybody. So I can only respond to all the demands which you have made by saying that every one of the demands, I mean, how can a member of the bar who has ascended to the bench regard any of these demands as not being reasonable? And these are genuine demands which have to be dealt with step by step. We have to take each one of them in collaboration with each other. I think listing has been a real problem in our court. Justice Lalit, my distinguished predecessor, has taken very concrete steps towards making a more transparent system. I propose to continue that, build on the work which has been done very ably in a short tenure by Justice Lalit. We need to make the listing of our court transparent, objective, and perhaps my aim is to employ technology so as to remove the element of the human interface in the listing process. Because all discretion tends to become a discretion which is capable of being, perhaps not being employed properly. So lawyers pointed out to me the defects, the process of verification, the process of removal of defects. We've already started working on it, and we are trying to prepare SOPs so that it should not be dependent on who is the Chief Justice. I think it's also important that we institutionalize these processes. So it should not die down when 2 years down the line I'll be on this podium bidding farewell to you. It must be a part of an institutional mechanism. So I believe more than just dealing with ad hoc solutions to our problems, it's more important that we institutionalize our approach to the problems which the bar faces, whether it's in terms of listing or otherwise. Elevation of the members of the bar. As Chief Justice of the Allahabad High Court, I had the signet pleasure of having brought several judges of the High Court from the bar of the Supreme Court. I do believe that, lawyers land up practicing in the Supreme Court sometimes as a matter of fortuitous circumstance. It's never by design. Where you are is sometimes just a product of your circumstances. Somebody comes here to study law and then you settle down here and you become a member of the Supreme Court bar. I don't think many of us can say, well, I designed that I should be here as a member of the bar. Something which I can let out by way of a secret, which is that so many of us, when a young lawyer appears before us, the instinct which you have as judges who have come from the high courts is to say, is this person not good enough for being appointed as a judge of the high court? And I have my own list of lawyers which I have in my mind. I'm sure all my colleagues have that. And I've been constantly mentioning those names to the Chief Justices who have preceded me. And I'm sure that the Supreme Court, which has some of the best young minds in the country, would really be able to contribute very greatly to the enrichment of our high courts, so long as we balance, of course, the needs of the high court lawyers also to be considered for appointment. So this is really an ongoing process which we will follow. I think the chief problem which we have today is of judicial vacancies. There are 25% of the posts in the district judiciary today are vacant. 30% of the sanction strength in the state judiciaries is vacant. And of course, we have a few vacancies in the Supreme Court as well. I've laid a great amount of stress on technology. That's not because I have interest in technology, because I genuinely believe that technology can be a source of inclusion. But we have to also ensure that technology does not become a source of exclusion. We are about to launch into e-filing for the Supreme Court. Now let me tell all the members of the bar that the reason why we want e-filing is not to make some hi-fi modern method of filing in the Supreme Court. We are conscious of the fact that everybody who is in the Supreme Court is not at the tip of the pyramid. You have among the best who earn the highest fees, but you also have the massive base, the pyramid, the base of the pyramid, where lawyers earn small fees for the purpose of their daily existence. We are conscious of that. So we are also conscious of the fact that many lawyers may not have access to a good computer or access to the internet. So one of my missions has also been to ensure that those who do not have access to technology, technology must reach out to the members of the bar, just as it must reach out to citizens. It's not the other way around. So there should be no exclusion on the ground of technology. So all in all, I must tell you that this is really going to be a collaborative effort between the bar and the bench. I could go on for another hour about what plans we have in future in store. But as I said the other day, let our work do the talking and let not our speech do the talking. So I promise you that we'll work together and I expect the same promise from you that we'll expect collaboration between each other. We'll listen to each other. We'll talk to each other regularly. We'll be engaged in a dialogue with each other in the great belief and understanding that we are really part of one institution and we represent a common mission to deliver justice to our common citizens. I think I took a long time, but it's an emotional moment for me to come back to a bar to which I belong. And so you'll forgive me for my exceeding time. Thank you.
Sir, it was really fascinating to hear your life journey in the bar, starting from briefing Mr. Farid Nariman, Mr. Chitle, Ashok Desai, Mr. Ashok Sen, doyens of the bar. And you as a CJI speaking about the infrastructure in district court and the mindset, it would go a long way in improving things, sir. As you said, listing, you're trying to make it more transparent, will again go a long way in improving things, sir. May I now request, and before that I must compliment, over here in Supreme Court, we have the Judges Committee and we have the Judges Committee of Justice Call who sorted out the issue of security. Then we have the Judges Committee of Justice Gawai and Justice Suryakant, and because of this committee, the chambers could be sorted out. May I now request Mr. Vikas Singh, President SCBA, and Mr. Pradeep Kumar Rai, Vice President SCBA, to kindly present a memento to Honorable Dr. Justice G.Y. Chandrachud, Chief Justice of India. May I now request Mr. Rohit Pandey, Joint Secretary SCBA, to kindly give vote of thanks. Oh, I'm sorry.
Thank you, Rahul. We are grateful to the most anticipated Honorable the Chief Justice of India, Dr. Justice Dhananjay Yaswant Chandrachud, for accepting our invitation for the felicitation function. Sir, you are very much in demand, especially between young lawyers. They want to hear Lordship, to interact with you, Lordship, and to watch proceeding. We have never witnessed such craze for the Chief Justice of India, especially between the young lawyers. Sir, we have a great confidence in you that you will resolve all the issues of the bar on priority. जैसा कि आपने कहा और देश के लिए संदेश दिया है कि हम अपने कार्यों से देश के लोगों की सेवा करेंगे, ना कि शब्दों से। सर, हमें उम्मीद ही नहीं, पूरा भरोसा है कि इट विल बी ए न्यू एरा फॉर द सुप्रीम कोर्ट ऑफ इंडिया with an independent judiciary and empowered bar and bench. We thank Honorable Judges of Supreme Court of India, Honorable retired Judges of Supreme Court of India for gracing the occasion. We thank Mr. R. Venkati Ramani, Learned Attorney General for India, Mr. Tushar Mehta, Learned Solicitor General of India, Learned law officers, senior members and members of the bar, former President SCBA Mr. Dushyant Dave, former President SCBA Mr. P.H. Parikh, former Secretary SCBA Mr. K.C. Kaushik, former Secretary SCBA Mr. Vikrant Yadav, Mr. Manoj Mishra, President Skora, Mr. Sanasis Mukherjee, Vice President Skora, Mr. Devbrat, Secretary Skora, Mr. Sanjeev Kalgaonkar, Learned Secretary General, and other registrars of the Supreme Court of India, press, journalists, print and electronic media, office bearers and members of the Executive Committee of different bar associations, other distinguished guests and respected members of the bar for gracing the occasion. Kindly, I request Executive Committee to join for a group photograph. Join us for high tea at ground floor.
दे दो कुछ. Yeah. May I request President Mr. Vikas Singh and Mr. Pradeep Kumar Rai, Vice President, to kindly escort Honorable Mr. Justice U. Lalit, Chief Justice of India, Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India Designate, and Mr. R. Venkatramani, Learned Attorney General for India, to the dais. This itself is a sight. May I request Ms. Sangeeta Singh, Member Executive, to kindly present a bouquet to Honorable Mr. Justice U. Lalit, Chief Justice of India. May I request Mr. Mukesh Kumar Singh, Member Executive, to kindly present a bouquet to Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India Designate. May I request Mr. Vikas Gupta, Member Executive, to kindly present a bouquet to Mr. R. Venkatramani, Learned Attorney General for India. May I request Ms. Sonia Mathu, Senior Advocate and Senior Member Executive, to kindly present a bouquet to Amita Ma'am, Mrs. U. Lalit. Honorable Mr. Justice U. Lalit, Chief Justice of India, Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India Designate, Honorable Judges of the Supreme Court, Mr. R. Venkatramani, Learned Attorney General for India, Mr. Tushar Mehta, Learned Solicitor General of India, Amita Ma'am, Ms. U. Lalit, Shreyas, son of Justice Lalit and daughter-in-law Ravina, Shri Vikas Singh, President SCBA, Shri Pradeep Kumar Rai, Vice President SCBA, Mr. Manoj Mishra, President SCORA, Mr. Snehashish Mukherjee, Vice President SCORA, Mr. Devrat, Honorary Secretary SCORA, Senior Advocates, former President Mr. P.H. Parekh, Mr. Rakesh Khanna, former Secretaries Mr. Vikrant Yadav, Mr. K.C. Kaushik, Senior Advocates and my fellow colleagues at the bar, a very good evening to you all. Today we have gathered here to bid farewell to Honorable Mr. Justice U. Lalit. It is an emotional moment for the whole bar, as Sir was practicing in this court before his elevation as a Supreme Court judge. How much the bar loves him can be seen with the way people have turned up here. There's no place to stand, and what I am told, people are still coming. He was the second lawyer who was elevated directly as a Supreme Court judge from Supreme Court Bar Association to become CJI after Justice S.M. Sikri in 1971, that is after more than 50 years. He has been part of this institution for more than 40 years, around 32 years as a lawyer and 8 years as a Supreme Court judge. He has been an advocate on record in this court, thereafter an arguing counsel, and then a designated senior advocate who was designated by the Supreme Court in 2004 and was one of the top senior counsels of this court. He was appointed as a Supreme Court judge on 13th of August 2014 and appointed as Chief Justice of India on